Let us start with a tough but vital question. If you were sued tomorrow, whether from a business dispute, a car accident, or any unforeseen event, how much of what you own could someone actually take? Your savings account, your investment portfolio, your house? For most people, the answer is terrifying, almost all of it. We live in a litigious world, and whether you're a doctor, a business owner, a landlord, or even just someone with a healthy retirement fund, you are a potential target. But here's the critical distinction that forms the bedrock of everything we lines discuss. There is a world of difference between illegally hiding assets to defraud creditors and legally protecting them through smart, proactive planning. The first will land you in jail for contempt or fraud. The second is not only your right, but a responsible part of financial stewardship. This isn't about avoiding legitimate debts. It's about creating a legal structure around your assets so that they aren't the low-hanging fruit for every potential claimant. Think of it not as building a wall to hide behind, but as installing a legal firewall, a series of separate, fortified compartments so that if one area of your life faces a crisis, the entire ship doesn't sink. In this guide, we're going to walk through the foundational legal strategies that financial advisors and attorneys use. The golden rule, which we will repeat, is that timing is everything. These strategies are most effective when implemented well before any legal threat is on the horizon. The very first and most powerful layer of protection is a fancy trust or an offshore accounted as understanding and maximizing what are known as statutory exemptions. These are protections written into state and federal law that declare certain assets off limits to creditors in many situations. They are your automatic first line of defense, and many people don't even know they exist. The most significant one for most families is the homestead exemption. This law, which varies wildly from state to state, protects a certain amount of equity in your primary residence from seizure. In some states like Florida and Texas, the protection is virtually unlimited for a primary home. Now, let us move to the core strategy for protecting business and investment assets, the use of legal entities. This is where we separate your personal risk from your professional or investment activities. If you own rental property in your own name and a tenant slips and falls, they can sue you personally and go after your personal savings, your car, everything. The solution is to hold that property in a separate legal entity, most commonly a limited liability company, LLC. The key principle here is the corporate veil. When formed and maintained correctly, an LLC is viewed as a separate person in the eyes of the law. A lawsuit against the LLC is generally confined to the assets inside the LLC. Your personal assets are, in theory, shielded. This is why you see savvy real estate investors hold each property in its own separate LLC. It creates individual firewalls. But here's the insider secret. An LLC's protection isn't automatic. You must respect the corporate formalities. That means having a separate business bank account, not mixing personal and business funds, a fatal error called commingling, filing annual reports, and keeping proper records. If you treat the LLC like your personal piggy bank, a creditor's lawyer will pierce the corporate veil in court, and that protection will vanish instantly. For higher-risk professions, like doctors or architects, more robust entities like a professional corporation, PC, or pairing an LLC with a malpractice insurance policy is the standard approach. The common mistake is thinking that a single LLC for your entire, multifaceted business empire is enough. For true protection, you need to segment risk. Your high-risk activity should be in a separate entity from your stable, income-producing assets. For protecting personal wealth that you want to secure for your family's future, the premier tool is the trust. Not all trusts are created equal for asset protection. A revocable living trust, while excellent for avoiding probate, offers zero protection from your own creditors because you still control it. The powerful tool is the irrevocable trust. When you transfer assets into a properly drafted irrevocable trust, you legally give up ownership of them. They are now owned by the trust for the benefit of your chosen beneficiaries, like your spouse or children. Because you no longer own them, your creditors generally cannot reach them. A specific, powerful type is the Domestic Asset Protection Trust (DAPT). Currently allowed in a growing number of states like Nevada, Delaware, and Alaska, a DAPT is a unique irrevocable trust where you can even be a discretionary beneficiary yourself. Yet the assets are still protected from your future creditors after a certain period known as the clawback period. Setting up a trust is a serious, sophisticated step that requires an expert attorney. The pro tip is to fund it with assets that are likely to appreciate like real estate or stock because all that future growth happens inside the protected environment. The psychological hurdle is relinquishing control, but that's precisely what creates the legal barrier. It's the ultimate expression of planning ahead. We must also discuss what asset protection is not. It is not a last-minute, desperate scramble. Any transfer made when a lawsuit is imminent or already filed is considered a fraudulent conveyance. Courts will absolutely reverse such transfers, and you could face serious penalties. The time to build your structure is when you are financially healthy and no specific threat exists. Furthermore, asset protection does not mean you stop paying your taxes or your legitimate bills. Tax obligations and court-ordered family support like alimony and child support are almost always impossible to shield from. Finally, asset protection is not a do-it-yourself project. While understanding the concepts is crucial, the implementation requires coordinating with a team, a knowledgeable asset protection attorney, a CPA, and a financial advisor. A common and costly mistake is buying a generic shell kit online without counsel tailored to your state's laws and your personal financial picture. That template will have fatal flaws. In conclusion, legally protecting your assets is a proactive, multi-layered process of planning. It starts with knowing your statutory exemptions, your homestead, and retirement accounts. It builds with using legal entities like LLCs to compartmentalize business and investment risk. And it culminates for substantial long-term wealth in sophisticated tools like irrevocable trusts. The overarching theme is separation. Separating personal from business, separating high risk from low risk, and in some cases, legally separating ownership from control. This isn't about fear, it's about prudence. By taking these steps during times of calm, you ensure that the wealth you've built can serve its intended purpose, providing for your family, funding your retirement, and supporting your goals no matter what storms may come. Disclaimer: I am not a lawyer, CPA, or licensed financial advisor. The information in this video is for educational and informational purposes only. It is not legal or financial advice. Asset protection laws vary dramatically by state and country and are highly complex. You must consult with a qualified attorney and tax professional who specialize in asset protection law in your jurisdiction before implementing any strategy. Do not attempt to shield assets from existing creditors or legal judgments, as this may constitute fraud.